Hello everyone, my name is Mark Veloso, a contributor with Litigation Help, and welcome to our video series entitled Case Law Minutes, where we'll highlight the most frequently cited family law cases listed on the Ontario Superior Court website. Our video today is on Homsi v. Zaya, decided in 2009 by the Ontario Court of Appeals. This is a family law case that concerns the issue of disclosure. Please remember that this presentation is for general legal information only. For advice specific to your case, please consult a lawyer. In Homsi v. Zaya, the parties were married in 2003. The wife had a daughter from a previous marriage, and the parties had one son together. During the marriage, the wife was employed as a hairdresser. She experienced sudden health problems due to her pregnancy that made her unable to work for 3 years. Meanwhile, the husband worked as a car salesman until 2005 when he lost his job. After that, he was largely unemployed. The decrease in the family's income caused the couple to incur financial problems. The mortgage on their home went into arrears and other debts accumulated. Marriage began to deteriorate in the fall of 2006. The husband took the couple's son and moved to Montreal to be closer to family. In January 2007, he sold the matrimonial home in exchange for the purchaser assuming the mortgage and other debts. No money exchanged hands. A short time later, the husband commenced his application for divorce. At the time of the trial, the husband was working in Montreal for $12 per hour. His T4 slips indicated that he was earning roughly $19,000 per year. The wife, meanwhile, had quit her job in order to qualify for legal aid. She was receiving support from Ontario Works. At trial, the judge imputed an income of $30,000 per year to the husband and ordered spousal and child support payments. The issue before the court was whether child support and/or spousal support could be awarded on the basis of imputed income. There is no automatic entitlement to spousal support under the Family Law Act. While there is an entitlement to child support, the amount of support is determined based on the facts. At trial, the husband presented the only reliable evidence, in the form of his T4 slips, demonstrating an annual income of $19,000 per year. The Court of Appeal argued that the onus was on the party seeking to impute income, in this case, the wife, to provide evidence in support of that desired amount. This reasoning can be found in paragraph 28 of the decision. Another issue facing the court was whether the trial judge had erred in awarding an equalization payment in the absence of financial evidence. The husband contended that the trial judge awarded an equalization without any evidentiary support with respect to either the value of the house or the furnishings. They rejected the husband's reasoning, stating that the onus is on the party asserting the value of an asset that he or she controls to provide credible evidence as to its value, and the husband had provided nothing. In the end, the court in Homsi v. Zaya came to a mixed decision based on a lack of financial disclosure available. Allowing the husband's appeal only in part, the court set aside the spousal support award in its entirety. However, the wife was still awarded child support for the son and an equalization payment from the sale of the matrimonial home and its furnishings based on the imputed value of $12,000. The legal rule or ratio decidendi arising from this decision is that incomplete or absent financial disclosure may result in an adverse inference drawn against the party making the claim. To learn more about the court's reasoning in this decision, you may access the full case on the CanLII website link provided above. Thank you for watching, and I hope you enjoyed this installment in our series Case Law Minutes.